Hi, I'm Kellen Bryant, and in this video I'm going to explain the 3 important steps you should take before you hire a probate attorney in Florida. And I'm your presenter, Kellen Bryant, and I'm a probate attorney, and I practice out of, I'm a Florida licensed attorney practicing out of Jacksonville, Florida office, and I also serve other parts of Florida as a probate attorney. Why watch further? Sometimes attorney is not even needed to transfer the assets to the beneficiaries. You don't need an attorney. And so this video is going to explain on whether or not you need an attorney, even if you don't need an attorney, what to do. And so hopefully you'll get a lot of value out of watching this entire video. So I'm going to give you an overview of what we're going to talk about is the immediate need of funeral home, what kind of questions they're going to ask you, what kind of answers you're going to need to give. This can apply to everybody. 2, I'm going to go over the reading of the will, and last I'm going to go over the data collection you're going to need to do, whether or not you need an attorney. All right, so what do we do at the funeral home? Your loved one has just passed away. You're starting to have some questions about legal or financial issues. What do we do at the funeral home? So first, paying the funeral home. The funeral home hopefully has been prepaid, but a lot of times they will not provide any services without being paid. So if you have a prepaid funeral contract, you want to go to that particular funeral home where the prepaid funeral was purchased. If you have available liquid funds, like because you have a joint account, that's a good place to pay for the funeral home. And last, some funeral homes will work out arrangements with you if you have a life insurance policy that they can get paid out of. So that's what you can take care of the bill with. Death certificates, how many? Usually the amount of death certificates is dependent on the amount of assets and expenses and people who need to be officially notified. There's no general rule of thumb, but maybe 8 to 12 on average, depending. And because you can always get more, but it's a pain to get more, and it doesn't hurt to get six long form, 6 short form. The long form has the cause of death on it. The short form does not. You also at the funeral home should notify income sources. So the funeral home usually takes care of it, but you can mention it and coordinate with the funeral home. Are they going to contact Social Security? Are they going to contact VA? Usually you'd contact the private pensions, but if you don't contact them ahead of time, so for example, if your loved one dies on the 30th of the month, Social Security is not notified, and the Social Security payment comes in on the 1st of the next month. Well, once Social Security is aware that somebody's passed away, that Social Security payment after they died actually has to be returned to Social Security. So that they need to be notified immediately because they're going to get their money and they're going to find out your loved one's deceased one way, shape, form, or another. All right, the reading of the will. The reading of the will is actually a myth. There is no official reading of the will in how things work. It's a product of fiction and TV shows and movies and so forth. So the reading of the will, it's a myth, and really who gets what's depending on how the accounts were set up, whether or not there was a joint owner or beneficiary, and if there was none, if it's just another person. The reading of a will is not necessarily done in an attorney's office. I'll explain what has to go on next. So you need to find the original will. The original will is what counts. And if you're watching this video and you think people are out there that will not like what is seen on the original will, you're going to need to file that at the clerk of court in the probate department and have the deceased person's Social Security and cause of death, Social Security and date of death handy so you can file the original will and for safekeeping at the courthouse. And then before you file, of course, make a photocopy of it so you can have it accessible to you or share it with whoever you want to share it with or have it available for an attorney if necessary. The main thing is when we see the reading of the will or see the will is we're looking for who is the personal representative. That's the term in Florida for the executor or executrix. So the personal representative is the person that's in charge of the estate and handling and administering the estate. If you're watching this video, it's probably you. Usually in most wills, there'll be a section that nomination of personal representative and so forth. And it'll say as follows, my daughter, Susie Jones, will be my personal representative, and if Susie Jones does not survive me, then my son, Davy Jones, will be the successor personal representative. So Susie's not with us in my example, then Davy's going to be in charge of the estate. Now, a word on who gets what. I would not jump the gun on that. Telling people, unless it's just clear as crystal, everyone's alive, nothing's to be disputed in the will. Most families, they might say, I have 4 kids, and all 4 get an equal 1/4 share. And all 4 of the kids are alive. Yeah, that's probably okay to share and have it generally notified. But you might want to hold back if probate is needed, and talk with the attorney about how to approach who gets what, because maybe there might be other legal events, legally relevant events that have occurred that it may not be readily apparent from the front and just the 4 corners of the will. So that's something, and you definitely don't want to get somebody's hopes up one way, shape, form, or another. Okay, third part is collecting data. So of this video, so the person named as personal representative should find out whether or not probate is required. So I got you some preliminary advice and suggestions about what you should do when somebody passes away. And now we're going to do some data collecting to figure out whether or not probate is actually required. So we're going to have to collect data. So you're going to have to hunt it down. So you're looking at looking at the mom or dad's papers, important papers, safety deposit box, fireproof box. It's a place where they keep their important papers, maybe there's certain desks at the house, and you're going to try to look for bank statements, tax statements, tax returns, and figure out where they held assets, because it may not be readily apparent from your first search, and you might have to even dig deeper and hunt it down by finding a tax return and seeing who the CPA was, and maybe the CPA might have information about assets, because if you have an asset that's producing income and you're claiming it, you should be claiming it on your tax return. These CPAs should know about the existence of an asset or not, and maybe even the history of that asset, whether or not a certain particular stock was sold previously or a piece of property has been sold. Those type of things are very helpful looking at tax returns and so forth. Unfortunately, the downside of a lot of this online banking, online statements is sometimes families aren't savvy or aware of existing accounts because it's only available online. So, so that's why the tax returns are very helpful. But if they're still getting statements old school way, you might be stuck with just waiting on the mail and seeing what kind of statements roll in. Also, you can look at the property records in the city where your loved one may have lived or owned property, whether it's the property appraisers websites in Florida or the public records in Florida. Each county has each where you can look up information regarding whether or not somebody owns real estate. And as for like old life insurance policies, that's when it gets a little bit tricky. You might need our help. So going back real quick, when you have all your data, the key is what you're looking for is who owned the property, are there joint owners, can you tell if there's beneficiaries? Because in those cases with joint owners, beneficiaries, or the existence of a trust, you may not need probate. If there's a trust, yeah, you might want to go to an attorney to help figure out how to make everything work and do everything right. Might be as simple as a one meeting one appointment meeting and you take care of it with a revocable trust. But other times it might be a little bit more than that. But if we determine that probate's not needed because there are beneficiaries on the accounts or there's joint owners, then you're going to want to go ahead and send in your life insurance claims and just go online, or look at the statements, find the number, submit a claim that way. You're going to need the death certificates available. You want to look to get the car title transferred if there is one. The car maybe is listed in the will, or if it says, my car is divided equally between my two kids, maybe the two kids are probably going to have to go to the tax collector's office to get title changed, and you're going to want to grab the title and registration and the death certificate, and they have and maybe a photocopy of the will if there is one, and you're going to have to get a specific form at the tax collector's office to change title. Another consideration, even if probate's not needed, if there's a surviving spouse, the surviving spouse needs to consider getting their estate plan up to date or doing one, because when there's a couple, it's most accounts are held jointly, and if one spouse dies, the other spouse will get all the assets, no problem, no probate's needed. But if that surviving spouse passes away, then a probate will be required if there's no trust in place or everything's not set up correctly. So you definitely want, even if there's no probate needed, you're going to want to look at the surviving spouse's existing estate plan. There's another helpful suggestion is to notify the credit bureaus of someone's deaths, and you can pull a credit report, see if there's any outstanding debts, and notify the credit bureaus of someone's death so there's no identity theft of stealing or trying to take out credit on your deceased loved ones, Social Security. So you can notify credit bureaus of death, and also consider talking to your accountant tax preparer about filing a final tax return so the IRS knows not to expect taxes under a certain Social Security number because this person has passed away. So again, when is probate required? It's when there's only one name on an account. That's or on an asset, such as property. So if you go into a bank and say, "Hey, my mom's died. Here's her death certificate. Here's a photocopy of the will," and they say, "Oh, you're going to need to get letters of administration or a small estate affidavit or summary administration," that means the bank's not going to give you access to that money, and they're waiting for a court order. That means you need to go to probate. So you need to get letters. Another reason why probate is going to be required is if the house is only in the name of the deceased person. Now, you may have power of attorney. The power of attorney no longer works after somebody passes away. So if the house is in the name of a deceased person, then you cannot sell the house without doing a probate. You can list it. In a lot of cases, people do list their house if there's a deceased, if their loved one's deceased. But when it comes down to it, when the title company runs the titles report, they'll see that the house is in the name of your deceased loved ones, and so they're going to make you go to probate to figure out who the actual owner of the house is. And essentially, the probate proceedings transfers title to the deceased person's loved ones according to will, or if there's no will, according to laws of intestate. And then the closing can go from there. So that's when a probate's required. And just generally assets without a beneficiary or joint owner. So that sometimes happens if mom or dad bought a life insurance policy and named the other spouse as beneficiary and did not name a contingent beneficiary. That means the life insurance policy had no beneficiaries. The policy will pay out to the estate of your loved one. So you need to look for assets without a beneficiary or joint owner, a house without a joint owner, and the bank locks down the account. That's when a probate is required. So if you need to hire an attorney, I have a screenshot here of attorney's fees that are considered under Florida law to be reasonable. So this is just kind of a rule of thumb of what is reasonable, and things can change below or above these figures. But as you're seeing here, for the smaller estates, that's a flat $1,500 fee to the attorney. The court costs are generally between $250 and $400, depending on the size of the estate and what assets are in the estate. Larger estates above $100,000, $200,000 will be at a percentage of the estate a lot of the time, and you can find out from whatever attorney you're talking to if this the type of estate could be subject to a flat fee or an hourly fee. And this schedule here on this slide will give you a general rule of thumb about what to pay for your attorney's fees for a probate. Now, thank you for watching the rest of this video. If you want to have help on the contents of the video, I have a checklist ready for you that you can download and follow along. And at the end of the checklist, you'll figure out whether or not you need an attorney, and I'll have a worksheet that you can work through on tracking your loved one's assets and whether or not we need probate, who you should call for certain things, and who might be entitled to certain things. So the checklist will be your helpful guide on this, and you can click on the link on this page to download the checklist, and off you go. So thank you for watching. This is again Kellen Bryant, and I hope this video was informative to you. Thanks.